Good evening, ladies and gentlemen. On behalf of International Arbitration Center, AECCI, IAC, that is an initiative of the Asian Exporter Chamber of Commerce and Industry, a chamber recognized by the Ministry of Commerce and Industry, Government of India. I, Swarn, Executive Director, welcome you all here. And in the first episode of Friday webinar series, we are delighted to have with us students of LLB, LLM, legal professionals, and the members from the business and trade community. So today's webinar, it is on very relevant and practical subject, that is arbitration in international trade contexts. In era of global trade, disputes are inevitable, but how they are resolved, this is more important to know, because this defines the credibility and the strength of the commercial relationships. Arbitration has emerged as the, you can say, most preferred mechanism to resolve the international trade disputes. This 1 hour session will provide valuable insights into the subject. And very briefly, let me tell you about the objective of establishment of this International Arbitration Center. We just want to promote the institutional arbitration in matters with regard to the domestic and the international trade. Arbitration is promoting awareness of alternate dispute resolutions, awareness about spreading about the trade practices, arbitration framework, and some young minds to explore arbitration as a specialized career path. So, through initiatives like this, the Friday webinar series, and our other educational programs, we just aim to bridge the gap between the academic understanding and the practical dispute resolution. Before we start, let me just give you the few instructions. This entire session will be conducted by our esteemed speaker. I'll be introducing very soon, and participants will not be having the access to the mic. You are requested to put your questions in the chat box. Towards the end of this session, we'll be taking all your questions, and then we request you all to keep engaging, keep active with the session. Now, this is my distinct honor to introduce our esteemed speaker, Mr. Vinod Haritwal. Mr. Haritwal, he is a highly accomplished professional holding qualification of FCA, LLB, CS, and BCom, and has been a merit rank holder at all levels, including securing an All India first rank. He brings over 45 years of leadership and professional experience, having served as CEO and director across sectors such as manufacturing, private equity, investment banking, venture capital, and alternative dispute resolution. As a sole arbitrator, he has rendered awards in 63 commercial disputes, the majority being institutional arbitrations. And he is empaneled with numerous reputed international and Indian arbitration center and has conducted both physical and online arbitration proceedings. His long experience as arbitrator makes him exceptionally well suited to guide us on the topic. So, with great respect, I now invite Mr. Vinod Haritwal to kindly take over the session. Over to you, sir.
Thank you, Swarnaji.
Yes, sir.
Good evening, all the participants. Welcome to this seminar. What I plan to do is I'm going to take it for granted, or I'm going to presume that most of you are familiar with the concept of arbitration. So I'm not going to take you through what is written in the law, because that's very easily understood by just reading it. What I'm going to discuss with you is only international trade contracts, and also the principles and doctrines that the currently legislature as well as judiciary has been propagating, so that we know what is the current global trend. Swarnaji, can you share the PPT?
Yes, sir. Yes.
Yes. So as you know, the arbitration law is through a statute called Arbitration and Conciliation Act of 1996. This law came into existence in 1996 by overriding an earlier archaic law of 1940. And this law reflects the current contemporary trade position internationally. So can we go to the next slide, please? Next slide, please.
Yes, sir.
Yeah. So as I said, the growing cross-border trade and the global promotion of ADR, that is alternate dispute resolution, as a forum for settlement of disputes, and India's evolving judicial as well as legislative outlook to integrate and align with the global trends is what brought about this law that is behind this particular act. Next one, please. Just very briefly to talk about what arbitration is for those who are not very familiar with it. It is a private mechanism of resolving disputes, predominantly commercial disputes, not necessarily only commercial, but predominantly commercial disputes, through uh, through an intermediary, through an arbitrator, who is the equivalent of a judge in a court, but appointed by the parties themselves, where all the processes of hearing out the merits and demerits of the case from both the parties, the timeline, the process, the location, that is venue, who the arbitrator would be, etc., is all determined by the parties themselves. The order that is passed by the arbitrator finally has the same merit and the same value as the court order, as an order passed by a court as a decree. So it can be enforced in the courts the same way as a decree can be enforced. Another major advantage of arbitration is that the entire matter remains confidential, unlike in the case of case of a judicial proceeding, which is open to public. This remains entirely confidential. There is also a mechanism of institutional arbitration available, where if the parties do not want to decide who it should be or what the process should be, they can go to these institutions like this chamber that we are right now told, who then will appoint an arbitrator from their panel, and the arbitration process will be governed by the rules of that institution. So that makes it easier for the parties. The advantage in this is if the right institution and the right arbitrator is chosen, then the process can be very fast, can be economical, and can be very flexible in terms of what needs to be done and what need not be done. Next slide, please. Next slide, please.
Yes, sir.
So this law that we have is based on ancestral model law, which was passed in 1985, and I think it was modified in 2006. So the Indian law is up to date, has been updated in line with the changes that were made in 2006 through an amendment in 2015. And as I said, this repealed the old law of 1940. Yeah, next one, please. Yes, next one, please. Next slide, please.
This one, sir?
No, next one. Yeah. No, no. Previous one. Previous one. Previous one, please.
This was
Okay.
the
See,
last
the
one.
law is divided into four. No, the previous one, but that's okay. Yeah, this one. No, the next one. The next one. So the law is divided in four parts. The first part deals with arbitrations that are held in both domestic arbitrations and international arbitrations. Part 2 deals with awards passed by arbitrations which are based outside of India, called foreign awards. The third one is it deals with what is called conciliation, which is different from arbitration, where a third party, an independent party, tries to bring both parties together for a mutual settlement. Conciliation has now been carved out of the law into a separate law called Mediation Act. So it has been expanded and taken out of this act into a separate act. We will not discuss that today. So these are the two important parts. The part one, which deals with the India seated arbitration, and this part two, which deals with the uh, 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 arbitrations held outside of India. Next one, please. Next slide, please. Yeah. So let's
Next to
see
this, sir.
what is international commercial arbitration. No, this one is fine. So let us see what is international commercial arbitration. Now, Section 2(1)(f) of the Act defines what is international arbitration, and it simply states that if at least one party to the arbitration is either a foreign national or a person habitually resident outside India, or a body corporate, which is a foreign body corporate, or a foreign government, or an association of persons or body of individuals that's the control of which lies outside of India. So as you can see, the criteria used by Indian law is party-based as to who the party to the law to the arbitration is, not based on location of the let's say performance of the contract. So to take an example for let's say there are two Indian parties, they get into a contract for a project that is based in Africa. Any dispute arising out of this contract will be a domestic arbitration, although the project is in Africa. Whereas if there's an Indian party and a foreign party, but the project is in India, even then it will be an international arbitration, going by this definition. The main criteria here is the seat of the arbitration. So if the seat is in India, so even though it is an international commercial arbitration, Part A will apply. Part 1 will apply. But if the seat of arbitration is outside India, then Part 2 will apply and will be considered as a foreign award. The landmark judgment in this case is that of Balco, which we will discuss a little later. So next slide, please.
Yes, sir. 1 minute. I think, sir, I need to. Yeah. Yes. Why it's taking time to switch over to the next slide.
Hmm.
For a moment, sir, I'm stopping this
Okay. So
screen sharing, and again I'll come back to
you want to
this.
restart? Okay. Okay, restart. So this is what we saw is the international commercial arbitration. Now, distinct from this is a foreign award. Foreign award is an award passed in an arbitration which is based outside of the country. So as I said, even if both the parties are Indian, but if they decide in their agreement that the seat of the arbitration, that is the arbitration will be based outside of India, then it becomes the award passed in that arbitration becomes a foreign award,
Yes.
and part two of the act applies to that. We will discuss foreign award in more detail later on. So just to distinguish between international arbitration, international commercial arbitration, and foreign award, the okay, I presented the distinction between the two of them in the next slide. So next slide, please.
Yes, sir. Yes, sir. Shared.
Yeah. So as we see, the nature is that in case of international commercial arbitration, it is the arbitration process, whereas in case of foreign award, it's an award, an order. The legal provision is, as I said, in case of international commercial arbitration, Part 1 applies, and in case of foreign award, Part 2 applies. The determining factor is that the nationality of the nationality of the parties is what determines the international commercial arbitration, whereas foreign award is specific to a seat of the arbitration. The purpose is here decides the nature of the dispute, whereas here it is the enforceability of the award that is passed. Indian court jurisdiction in case of international commercial arbitration is there at all levels. So it is there for appointment of arbitrators, it is there for interim relief, it is there for setting aside, it is there for the appeal, as well as for enforcement. But in case of foreign award, Indian courts can only play a role for granting interim reliefs or for enforcement of the awards. So this is the difference between these two. Next slide, please. The earlier one? The previous one? Yeah. So as we've seen, no, next one, please. Yeah. Yes. So as we see, what is crucial here is a seat. Now, seat is where the arbitration is, the arbitration award is passed. It is distinct from venue. Now, for example, as I said, the seat may be outside of India, but the actual arbitration process might be held in India. The venue is where the proceedings take place, whereas the seat is the legal seat where the award is finally passed. The seat determines the procedure as well as the court jurisdiction. So if, let's say, the seat is outside of India, then the procedural law of that country will apply, and the jurisdiction of courts of that country will apply, even if the venue, that is the physical arbitration process, is carried out in India. So seat is the most crucial part. And as I said, the most important case law on this is the case of Balco, which we will discuss a little more in detail going forward. So next one, please. Yeah. So now what happens? Now, generally, the seat is defined in the agreement itself. So the both parties will decide that arbitration seat will be in such and such location. But let's say if for any reason the parties have not decided the seat, it is not mentioned in the agreement, then how is the seat determined? So the in various case laws and both India as outside as well as outside, the principles that have been applied are that if a venue is mentioned and there's nothing in that agreement indicating that the intention of the party was that the seat is going to be different from the venue, then venue is the seat. This is called the Shashua principle, that venue becomes the seat if there's nothing contrary to indicate that seat is supposed to be different in the agreement. Now, seat can be different in various ways. Like seat could be indicated as saying, if the agreement can say, it may not name the seat, but if the agreement says that the jurisdiction of the courts in X country will apply, then although seat is not mentioned, by implication, the intention of the parties is that the seat is in that country. So it can be indicated indirectly. If nothing is indicated, then venue becomes the seat. Also, as I said, arbitration can be through an institution. So if parties have selected an institution which is based outside of India, for example, London Arbitration Center or Singapore International Arbitration Center, in that case, the governing the rules of that institution will decide where the seat will be. But let's say neither venue is defined, nor jurisdiction is defined, nor is there an institution involved. Then how do you determine the seat? So then what is applied is the closest connection. Closest connection is taking an overall view of various factors to decide what is the most convenient location to have jurisdiction over this case. So there it can be where the agreement was executed, where the cause of action arose, what are the nationalities of the different parties. Based on these, most convenient location is then finally decided by the arbitral tribunal or the court as the seat. So this is about the seat. Next slide, please. So as I said, if you were to sum up, when you become a seat by default, unless there's something contrary to something contrary indicated in the agreement, if something contrary is indicated, then that is considered, and the seat is decided based on what is indicated. If there's an institution involved, then as per the rules of the institution. And if no venue is defined or no institution is defined, then closest connection principle. Next one, please. As I said, the watershed judgment in case of seat as well as in case of foreign award. If you remember, I mentioned that foreign awards part 1 of the law of the act doesn't apply. Part 2 applies. Now, part 1 doesn't apply means the Indian courts do not have jurisdiction over this award. Now, there were two cases prior to Balco, that of Bhatia International and of Venture Global, which had held that Indian courts will have jurisdiction over foreign award. Now, that was quite contrary to the global outlook. So this made India a let's say, jurisdiction. Most global parties would then avoid India. Aluminium, famously known as Balco case in 2012, by a five-judge Supreme Court bench, let's say, changed it completely. Now, it shifted the outlook of India to the global outlook. So it became the same as internationally what is held, where it means Part 1 of the law of the Act will apply only to India-seated arbitrations. It will not apply to foreign seats. In this case, for example, the court applied the Sashua principle. The venue was considered to be the seat, and since the venue was outside the country, the seat was considered to be outside the country. So, if the seat is outside the country, then no case can be filed in Indian courts for setting aside the award. It can what the Indian court can do is only provide interim relief if the parties approach it, or after the award is passed, enforce the award. So this is a very well-known and a watershed judgment that has finally decided what intervention the Indian judiciary will have in case of foreign awards, and how is the seat determined. Next slide, please. For all practical purposes, the international commercial dispute is treated at par with domestic arbitration. So international commercial arbitration as well as domestic arbitration are at par, except for a few specific differences. The first difference is appointment of arbitrator. Now, as I said, generally parties appoint the arbitrator. But let's say if the agreement says one arbitrator, and parties are generally, in case of a dispute, parties do not come to an agreement on who that arbitrator would be. Or both the agreement says that there will be 3 arbitrators, then generally one party appoints one, another party appoints one, and the 2 arbitrators appoint a presiding arbitrator. And let's say those 2 arbitrators are not able to decide the presiding arbitrator. Then the law provides that any party can approach the court, and the court will then appoint an arbitrator. In that case, in case of a domestic arbitrator, the arbitrator is appointed by High Court or an institution recognized by High Court, whereas in case of international commercial arbitrator, it is Supreme Court or an institution appointed by the Supreme Court. So this is as far as appointment of the arbitrator is concerned, High Court or Supreme Court. The second is the jurisdiction. Now, as I said, jurisdiction of the court for interim relief or setting aside of the award or appeal. In case of a domestic arbitration, is the principal civil court, whereas in case of international commercial arbitration, it is the High Court. The third one is that for setting aside the award, which once it is passed, patent illegality is available as a ground for domestic arbitration, but is not available for international commercial arbitration. Patent illegality means that if on the face of it, the award seems against an Indian law, then the court can intervene. A court can set aside that award. But in case of international commercial arbitration, this ground is not available. So court is not supposed to get into whether on the face of it, the award is not in line with the Indian law. The last one is the fourth one is substantive law. Now, substantive law is the law that governs the. Okay, we'll talk about substantive law in the next slide. The substantive law in case of domestic arbitration is that of India. By default, it will be the Indian law that will be the substantive law for domestic arbitration. Whereas for an international commercial arbitration, parties have full freedom to decide which territories law will be substantive law. So the parties can say, although the venue is in India, but the law of Singapore will apply. In that case, the law of Singapore is considered. Time limit for domestic arbitration, the law provides a time limit of 12 months in which the arbitration has to be completed. This is extendable by 6 months by mutual consent of the parties. But in case of international commercial arbitration, no time limit has been specified. The only thing that is prescribed is as fast as it can. So, except for these specific differences, domestic arbitration and international commercial arbitration that is seated in India, they are more or less at par. So, when we discuss further, the principles that apply to domestic arbitrations also apply to commercial arbitration, international commercial arbitrations. Next slide, please. So, as I said, substantive law. Now, substantive law compared to the procedural law. Procedural law is the law that governs the process of arbitration and dealing with the arbitration award that comes out of that process. Whereas substantive law is the law that governs the contract in which the dispute has arisen. So generally, there is a contract between two parties to do something or to perform a certain activity, and the arbitration agreement is that in case there is a dispute in performance of that contract, then arbitration will come into vogue. So the main contract, the law that governs that contract is the substantive law. So as I said, for domestic arbitration, by default, it is the law of India, whereas for international commercial arbitrations, parties can decide it can be a law outside of India. Okay. There's another provision here in the Indian law that if substantive law is not specified by international commercial arbitration, then can the arbitrator or the arbitral tribunal go by the principles of equity and justice or fairness? The law says that can be done only if parties are specifically authorized the arbitral tribunal to do that. Otherwise, it has to determine a substantive law and go by that substantive law. Next slide, please. Okay. So now let's look at the fundamental principles that govern the arbitration process. The paramount principle in arbitration is party autonomy. Parties are the bosses in this process of arbitration. They decide who will arbitrate. They decide where the seat of the arbitration will be. They decide what the process will be. They decide the costs, so they decide the fees of the arbitrator. They decide the sharing of that cost between them. And of course, this is subject to the mandatory overarching public policy principles that they can't go beyond that. But otherwise, all calls are taken by parties. Parties can decide who the arbitrators would be, and the parties can also say that arbitrator will be appointed by an institution, in which case the procedure also will be determined by the rules of the institution. The costs also will be determined by the rules of that institution. But here, all decisions are taken by the parties. If parties do not decide something, then the arbitral tribunal decides these matters and proceeds. So this is the first principle, party autonomy. The second principle is, next slide, please. that the judiciary will have very limited intervention in the arbitration process. Yeah, next slide, please. Next slide,
Answer.
please. Yeah. So section 5 of, no, the earlier one, please. Earlier one. Yes, yes. Section 5 of the law of the Act specifically says that courts will not intervene in the arbitration process except where specifically provided. So Part 1 has certain sections which provide for the court intervention. Except for that, courts will have no jurisdiction over the arbitral process. Next slide, please. To the extent that, next slide, please. Yeah, correct. Please stay here. To the extent that the arbitral tribunal or the arbitral is considered competent to even decide its own jurisdiction. This is called the competence doctrine. That the arbitral tribunal, if let's say if a doubt is raised about whether the arbitral tribunal has been properly constituted, does it have the jurisdiction over this matter? Does has it gone beyond its scope? All these matters have to be raised first before the arbitral tribunal, and the arbitral tribunal takes a call on this whether the objection is valid or not valid, and courts do not intervene in this. So this is slightly contrary to general principle that normally uh, a, a tribunal is not supposed to decide its own jurisdiction, but here arbitral tribunal is completely authorized to take a call on that. Next slide, please. Yeah. So what are the interim measures, and who decides the interim measures? Now, what are the interim measures? On what grounds interim measures can be decided? I think I'm covering later on. But interim measures basically are for, one is for appointment of a guardian in case there's a minor involved or there's a person with unstable mind is involved in appointment of a guardian, or for securing the property, goods, money, etc. that is involved in this. So this is an interim order under Section 9 by a court, which is available only before the arbitral tribunal has been appointed. Once arbitral tribunal is appointed, court knows the scene, then the interim relief is also granted by the arbitral tribunal. Now, there's under Section 17, parties have to move the arbitral tribunal for interim relief. And the interim relief granted by the arbitral tribunal has the same force as an order passed by the court of law. So there is an appeal possible against the order of the tribunal for against this, but not setting aside of this award. So by default, the parties have to go to the arbitral tribunal for interim relief, not to the court after the arbitral tribunal has been appointed. Next slide, please.
Yes, sir. This is right.
The arbitral tribunal, there are two provisions in the law that the arbitral tribunal basically is the arbitrator, one or three, or with the arbitrators need to be either an odd number. So 1, 3, 5, whatever the parties decide. So even one arbitrator is normally called an arbitral tribunal. So when I say arbitral tribunal, I'm meaning the arbitrator. Now the arbitral tribunal has to be independent and impartial. That's a very paramount principle of the law. So there is a Schedule 5 in the Act which lists out various relationships. If those relationships are there between the arbitrator and the parties or the matter, then it gives the doubt that the arbitrator may not be independent or impartial. So by law, the arbitrator, when he is appointed, he has to disclose his relationships with the parties or with the matter as listed out in Schedule 5. And then the parties take a call whether they are willing to waive that relationship and still go ahead, or if the parties decide that they are not willing to waive that, then the arbitrator needs to be replaced. The second thing is there is a Schedule 7. If any of the situations described in Schedule 7 apply, then the arbitrator cannot be appointed. The only exception is the parties can still overrule that, saying that even though situation as under Schedule 7 is applicable, but we are fine with the arbitrator and the go ahead. So as you can see, in both cases, parties are supreme. They can decide to waive even a doubt. They can decide to waive a disqualification. So Section 5 is situations that give a doubt. Schedule 5 is the situation that give a doubt, and Schedule 7 are disqualifications of the arbitrator. Next slide, please. Okay. Now, in the beginning, I mentioned that arbitration process is a very simple process. The proceedings are the procedures that are normally followed in the court, which most people find quite cumbersome and difficult to understand, and then that's why you need a lawyer to help you. Whereas in case of arbitration, the processes are very simple. Two laws, that is Evidence Act and the Code of Procedure, do not apply to arbitration. So arbitrator need not go by the provisions of the Evidence Act and the Code of Civil Procedure code, but the parties can decide the process to be followed. In the absence of the parties, the arbitral tribunal can decide the process to be followed. Now, generally in international commercial arbitrations now, people are following the rules that are laid down by the International Bar Association has some rules laid down for taking evidence. So generally, most of the tribunals follow those regulations for taking evidence. Next slide, please.
Yeah.
So after, let's say, the matter has been heard by the arbitrator, both parties may have given a fair chance when they were documents have been perused, evidence has been seen. When the award is passed, the award must be in writing. It must be signed by the sole arbitrator if there's a sole arbitrator. If there are more than one arbitrator, then by the majority. It has to be a reasoned award. The arbitrator has to explain the reasons for deciding what the arbitral tribunal has decided. There has to be a date and place of arbitration, because place of arbitration decides the seat, so that decides the court jurisdiction. And as we saw, interim orders are possible. Interim awards are possible both for interim relief as well as for, if the situation warrants, the arbitral tribunal can pass multiple awards, a series of awards, and a final award. Yeah, next slide, please. Now, an arbitral award, once it is passed, as I said, courts have limited jurisdiction in this. Now, in case of, let's say, if in case the matter, a dispute has gone to the court and a court has passed an order on that dispute, by default, a higher court is available for appeal. And depending on what is the level of the court that has decided the matter in the first place, there can be multiple levels of appeals by default. Whereas in the case of an arbitration, that default appeal is not applicable. The award that is passed by the arbitrator can be set aside by a court only on limited grounds. And those grounds are these. And if you see that these grounds do not include merits of the case. So merits are decided by the arbitrator. Once it is decided by the arbitrator, the court is not allowed to get into merits or to look at the evidence again. What the court can look at is if there has been an incapacity of the party, or the agreement itself was invalid, or the parties were not given enough notice and time, or the matter was actually not arbitrable. But there are certain matters which are not arbitrable. We will look at those matters. In the law, certain matters are not arbitrable. So if the matter has not been arbitrable, or the award is on a matter beyond the scope of the arbitration. So when the parties appoint an arbitrator, they decide the scope that the arbitrator is supposed to decide on these matters. But if the arbitrator goes beyond that, then question if it is separable court can be set aside by the court. If that is not separable, then the whole award can be set aside by the court. Or if the the award is against the public policy of India. And the last is, as we talked earlier, there's a patent illegality in the award. So only on these grounds can the award of the arbitrator be set aside. Otherwise, courts are restricted from looking at the merits of the case. Next slide. Now, what is public policy? In the previous case, we talked about one of the grounds is a public policy. Now, public policy has seen a bit of seesaw as far as India is concerned. In the case of Renu Sagar Power, decided by a three-judge bench in 1993, which prevailed for quite some time, the interpretation of public policy was done fairly narrowly, and which was in line with the global trend, that it was restricted to the fundamental policy of Indian law or to interests of India, national interests of foreign relations, or principles of justice and morality. So it was limited to these three principles. However, then came a case of saw pipes. Next slide, please. Then came a judgment in case of saw pipes, which was decided by in 2003 by a two-judge bench, which actually went contrary to the judgment of Renu Sagar. Now they added patent illegality as a ground for as one of the grounds for public policy, saying that patent illegality of the award is also a public policy. Now this caused most awards to go before the court on the ground of patent illegality. This was against the principles of arbitration. So it got, of course, created a lot of problem both within as well as globally. And then finally, the legislature had to step in. Legislature stepped in and rectified this position in 2015 and made a specific provision that patent illegality is not public policy and will not be considered for international commercial arbitration and for foreign awards. Yeah. Next slide, please. Yeah. So as I said, in 2015, amendment was made in the law, which narrowed the public policy definition back to these three things, and it barred a review of the merits of the dispute. And public policy is restricted to these three areas. Next slide, please. Yeah, a little back we talked about arbitrability, that some matters are not arbitrable. Now, arbitrability is the general rule is what is called right in rem. That is, rights which are against the world at large are not arbitrable. What is arbitrable is only rights in persona, that is, specific disputes between parties are subject to arbitration. This was decided in a famous case called Buzela in 2011 by a two-judge bench of the Supreme Court. A recent case in 2021 by a three-judge bench in case of Vidya Dodia expanded this right in rem to a little more wider area, which is one is that if third-party interests are involved, then the arbitration cannot handle that because arbitration is between two parties. So if there are third-party interests involved, then that matter is not arbitrable. Second is if it relates to sovereign functions, like criminal cases, like insolvency cases, like cases, basically laws which are sovereign functions of the government, or specific laws have been, specific tribunals have been formed to handle those type cases. Those are not arbitrable. Then if it is, so I said, there are specific statutes to deal with it. And the last one is, if there is a fraud involved, then in the agreement itself, in the original agreement itself, then the case is not arbitrable. Next slide, please. So once the award is passed and it is not set aside, as we saw when it can be set aside, it is not set aside, then the award is to be can be enforced. Now, in case of international commercial arbitration, the award can also be in foreign exchange, because generally the commercial global trade will be in foreign exchange, so the award can be in foreign exchange. The enforcement of the we already mentioned who the right court for enforcement of the award case of international arbitration is. That is the High Court. And if a challenge is filed in the court, does not mean the enforcement cannot proceed. The enforcement can still proceed unless the court issues a stay order. Otherwise, the enforcement can continue. Next slide, please. Yeah. So the Act also provides for interests and costs. Now, Section 31A says general rule is that the cost of arbitration is to be borne by the unsuccessful party. Now, what does this cost include? It includes the fees of the arbitrator, all other legal fees, administrative costs. In case there's an institution involved, the fees of that institute, the charges and fees of that institution, the expenses of the witnesses, all these costs. General principle is that the unsuccessful party pays. But depending on the case, the arbitrator may decide to recover only part of the cost, or it may decide not to recover the cost from the unsuccessful party. There's also provision for interest. So interest from the date of default to the date of the award can be included in the award itself. And after an award is passed, if it is a money award, then interest is applicable on that amount till the amount is paid at the rate of bank rate plus 2%. And the current trend is that most courts and arbitral tribunals are enforcing recovery of cost and interest to discourage people from prolonging the matter and prolonging payments. That's the current trend, which is a healthy trend. Next slide, please. Since we are already reaching the time, I will skip some of the slides. So we can skip this slide. Let's go to the next one. This can be read in the law. I'll discuss the main principles. Okay, group of company doctrine. Now, generally, the arbitration is between two parties, as I said, and both parties are signatories to the agreement, the contract. Can a party who is not a signatory to the contract also be involved in the arbitration? Now, there is this case of Cox and Kings, where the Supreme Court, a 5-judge bench has held that in case there is a tight relationship between one of the parties and a third party, and that third party has been closely involved in the negotiations, in the execution of the contract, in the termination of the contract, etc., then that can also be brought into the arbitration and can be made liable for the consequences of arbitration. For example, here the specific case was that SAP, which is a German company, had taken a contract from Cox and Kings to implement SAP, which actually failed. So the contract was signed by the Indian arm of SAP, but the implementation of SAP ERP was actually handled by the German company. So the court went ahead and inducted the German company into the arbitration. So in some rare cases, even third parties can be inducted. Next slide, please. Okay. Can there be a two-tier arbitration in the sense? Can the arbitration agreement itself provide that the arbitration award passed by an arbitral tribunal will go for appeal before another arbitral tribunal, maybe a larger tribunal? Let's say first award is passed by a single arbitrator, it will go to a three arbitrator appeal. Law is silent on this, but in the case of Central Trade, the court, the three-judge bench of the Supreme Court has decided that this is perfectly in order, because as we talked, parties are supreme here. If the parties have so decided, so be it. So the parties can decide that there will be two levels of arbitration, first level and second level. Next slide, please. Third-party funding. Generally, in India, it is the impression that in India, third-party funding is not allowed. Third-party funding is a third party providing to one of the litigants on the basis that whatever the gain that party has from the litigation, part of that will be shared by the person providing the funds. Now, the Delhi High Court, this matter is not yet decided by Supreme Court. I am not aware whether this matter has gone to Supreme Court, but the Delhi High Court has decided that that champati and maintenance is not an offense in Indian law. So it is perfectly valid. However, the third-party funder, unless that third-party funder is also a party to the arbitration, cannot be held liable for the consequences of the award. Next slide, please. Stamp duty. Now, this is a very recent case of NN Global. Now, this is again a situation that Indian judiciary has gone in seesaw in the same very case. NN Global case in 2021, a three-judge bench decided that agreement which is not validly stamped is invalid. However, in 2022, a five-judge bench decided that an agreement which is not properly stamped is non-existent. It is void and non-existent. Then, in the same year, a few months later, a seven-judge bench completely reversed its position and held that inadequately stamped or improperly stamped agreement is still valid. It is a curable defect. It is not a defect that will make the agreement illegal or void. It is a curable defect. So once the stamp duty is paid, the agreement becomes valid. So the position now is that even if the agreement is not adequate, it can still proceed. It then make sure the amount of stamp duty is paid. Between there, the authority is given to the arbitrator. The arbitrator has to make sure that the right amount of stamp duty is paid before the award is passed. Next slide, please. Next slide, please. Okay, investment arbitration are generally between. No, sorry. Go back to the earlier slide.
Yes.
Investment arbitrations are generally within treaties between different countries. So they are outside the jurisdiction of the Arbitration Act. They are governed by the treaties. Next slide, please.
Okay.
The model I had put in their presentation a model arbitration clause. So I'll go to the what must be there in a model arbitration clause next. That these four things must always be there in the model arbitration clause to avoid any. Yes, next slide, please. Yeah, the first is the seat. As we saw, the seat is the most important. That decides the jurisdiction of courts. The second part is the will it be an institutional arbitration or will it be a ad hoc? Ad hoc arbitration is where the parties appoint the arbitrator. Third is the number of arbitrators, one arbitrator or three or five. As I said, it has to be always an odd number so that majority can be determined. And the fourth is the governing law. The governing law, both the jurisdiction over the process as well as the substantive law. These five things must always be captured in the arbitration clause. Next slide, please. Okay, foreign awards. Now, foreign awards can be enforced in India. Otherwise, the courts are not supposed to intervene or interfere in the foreign award. But they can be enforced in India only if award is from a territory which is a signatory to the New York Convention or the Geneva Convention. There are multiple conventions that have been that are in place. India is a signatory to the New York Convention and Geneva Convention both. So if it is passed in a territory which is a signatory to the New York Convention or Geneva Convention, then the award is enforceable in India. Otherwise, it is not enforceable in India. Number two, it must be a commercial matter, not a non-commercial matter. Now, in the New York Convention, there is also one more catch, that even if the territory, next slide, even if the territory is signatory to the New York Convention, India needs to declare that territory as a reciprocating territory. So not all signatories to the New York Convention have been notified by India as reciprocating territories. So only awards from reciprocating territories can be enforced in India. Non-reciprocating territories can be enforced only if they are signatory to Geneva Convention. So India enforces both Geneva Convention as well as New York Convention. Now, what the New York Convention and what the Geneva Convention is, there are a couple of other conventions. I am not going to cover those. One can always read them later. Yeah. So please go next slide, please. This is Geneva Convention. Next slide. This is the ancestral model law. Next slide, please. This is the dealing with investment treaties. Next slide, please. Singapore Convention. Okay. Singapore Convention is actually not for arbitration. Singapore Convention is actually for mediation. Why I'm mentioning it here? That in the law encourages the arbitral tribunal to try for mediation between the parties so that parties can settle the matter between themselves without the arbitral tribunal having to pass an award. So it is perfectly in order for an arbitral tribunal to try for a mediation before the arbitral award is passed. And in case of mediation, then there's a Singapore Convention that governs mediation. The Singapore Convention is ratified, so it is still not applicable to India. India has passed a new law, so mediation then that new law will apply to mediation. Next slide, please. Okay, so enforcement of the award in India, foreign award. It can be enforced by Indian court in the same way as a decree passed by that court. Requirements, as I said, are that it should be from a territory that is a reciprocating territory under the New York Convention or a Geneva Convention territory. Secondly, it must be a commercial matter. In those situations, the Indian law. And the third is cases similar to what we discussed earlier for setting aside of the award. In those kind of situations, the court can refuse to enforce the award. But if those kind of situations are not there, then the court will always enforce the foreign award as a decree of that very same court. Next slide, please. Which are the areas, which are the cases in which the court will refuse to enforce the award? Like we discussed earlier, party incapacity or invalid agreement or no proper notice or overstepping the jurisdiction, public policy, or non-arbitrability. Now, in these situations, the court will not enforce it. Otherwise, the court will always enforce the decree. Next slide, please. Okay, there is a famous case recently that all of you would have read about, was that between Amazon and Future Group. Now, there the award was passed by an emergency arbitration. When in that case, Singapore International Arbitration Center was the designated institution, and Singapore International Arbitration Center rules also provide for an emergency arbitrator, in which case, if the party approaches the institution will appoint an arbitrator within 70 immediately within a few hours, and the arbitrator will pass an order within 72 hours. Now, in the Indian Arbitration Act, there's no provision or there's no mention of emergency arbitrator. So the question arose whether the order passed by the emergency arbitrator is enforceable, is valid under the Indian. So the Supreme Court decided that when the Indian Act talks about arbitration award, although it does not mention emergency arbitrator, it includes emergency arbitrator too. So an award passed by an emergency arbitrator is perfectly within the Indian law, and it is enforceable. This has made a tool available to parties that in case of an urgency, an emergency arbitrator can be asked for, provided you are before an institution. So it is always advisable to go before an institution for your arbitration. Next slide, please. Okay, we can skip this. Next slide, please. Okay, so India has an arbitration hub. Slowly, there are institutions like MCIA, NDISC, or the chamber that is right now holding this seminar. There are various institutions of this type that are coming up in India. And with popularity of these, India is slowly becoming a popular place for even international arbitrations, which are not Indian parties. Some of the factors that are important that have been responsible for this are, next slide, please. Next slide. Yes. No, this is the challenges. Okay. So that basically the reason why India is now becoming slowly a popular place is because the judiciary as well as the legislature both have been taking a very proactive role and a very let's say global view of the matters. They are not hesitating in adopting principles which are applicable internationally and globally, and that is why people are now more comfortable coming to India for arbitration. However, some challenges still remain. One is, of course, the delays in the courts. Second is the logistic issues that we have here, enforcement backlogs. So these challenges need to be overcome, and then there's no reason why India should not become a popular hub like Singapore or UK or any other territory is. Next slide, please. The last slide. Next slide, please. Yeah. So the conclusion is that arbitration is a favored way of settling commercial matters, provided you draft the arbitration agreement properly and you appoint the right institution and the right arbitrators. So this is what my presentation to you all was. Unfortunately, that is not leaving time for questions. But what I can do is, these are my contacts, and I'll be happy to answer any questions that you send to me. Can you please share that slide again so that the people can note down the email ID and the phone, telephone number? Yes. So if you write to me,
and the same will be shared with the participants. Yeah.
Yes. So if you write to me,
1 minute.
Yeah, if you write to me or send me a message, I'll be happy to respond to your questions. Thank you. Thank you for the listening.
Sir, give me a moment, please.
Yeah, sure.
This address will be shared with all the participants over email also. So, yeah. Now I'll be able to share.
So please share it with everyone. Yes. So that they are most
this
welcome to write to me or send me a message.
Take note of that.
Yeah.
And in the meantime, I would like to thank you, sir, for this detailed and very insightful, with practical knowledge, a very good session we had today. I think this is okay. Everybody would have taken the note of the contact details of sir. So in any case, we'll be sharing the same over email also. And once again, I can't even see any questions posted by the participants. By chance, if you have any urgent questions, you can write here, or you can share or email with us and with sir also. So all those will be answered very well on time. Yeah. And once again, on behalf of AECCI management, I would like to thank sir for this insightful session, to all the participants for your presence, for your time, for sharing the knowledge by the sir. Thank you, everyone.
Thank you. Thank you.
Thank you, sir.